We're in a place where few business people ever want to be, a courtroom. We're here to talk about a problem which increasingly brings people to court, sexual harassment.
I'm Paul Sorensen. This is my partner, Val Simmons. We're litigation attorneys at Warner Norcross and Judd. As attorneys, we represent employers and employees in court faced with claims of sexual harassment. And a question we often hear is, how did it ever get to this point?
With other attorneys from Warner Norcross, we will tell you what sexual harassment is and what it is not. We will help you to understand the importance of adopting a policy, and we will explain to you how to investigate and resolve a claim of sexual harassment or other related inappropriate conduct in the workplace.
It's important for every employee to understand that sexual harassment lawsuits are not brought only against businesses. These lawsuits include claims against individual managers, supervisors, and other employees who committed the inappropriate conduct or who failed to stop it.
You can be personally sued for sexually harassing conduct. A claim can be brought for assault and battery, interference with the employment relationship, or intentional infliction of emotional distress. In fact, criminal charges may be brought if the conduct included unwelcome touching.
No one wants to end up in court. We urge you to take the issue of sexual harassment very seriously.
I'm Lou Rabeau. With me is Karen Vanderwerf. We are employment lawyers. We counsel clients concerning employment policies and practices.
We want to help you understand sexual harassment from a legal standpoint. We also want to explain to you just how serious a charge of sexual harassment can be from a personal liability standpoint and even from a criminal standpoint.
The law recognizes two kinds of sex harassment. The first is called quid pro quo sex harassment. This occurs when a supervisor or manager promises something good or something bad if sexual favors are or are not granted. If a supervisor promised a raise or promotion in return for sexual favors, this could constitute sex harassment.
The law recognizes a second type of sexual harassment called hostile work environment. Under the law, a hostile work environment exists if someone is reasonably offended by the conduct.
Even if your conduct is not sexual harassment under the law, your employer may still find your conduct to be unacceptable. In either case, engaging in such conduct can be terribly expensive. It can cost you your job, it can cost you a marriage, it can cost you the respect of friends and family. It can cost you thousands of dollars in legal fees and damages, and it can even cost you your freedom if you're convicted of a crime. As you watch the next two scenes, ask yourself, is the supervisor engaging in quid pro quo sex harassment?
Good morning, Michelle. How's it coming?
Hey, I'm almost done. I can bring it to you.
That's okay. I'll just hang around here.
You know, I really don't think this is a fair review. How am I supposed to get promoted out of this department with a review like that?
I don't have time for this. But you know, you might be right. Maybe you can come by my place later tonight and we can discuss it further.
In the next scene, the conduct you see may contribute to a hostile work environment. Ask yourself as you watch this scene whether a reasonable person would be offended by the conduct.
Okay, so
must be like the fourth
yeah.
and everything.
Whoa, what a pair of legs.
Hey, how would you like to wrap those around me sometime?
She can come back anytime she wants.
Man, not bad.
When a supervisor plays favorites because of a personal relationship with an employee, it can result in a claim of sexual discrimination. As you watch the next scene, ask yourself, has the supervisor allowed her personal relationship with an employee to cloud her judgment?
Mary, I'm done with inventory.
Well, okay. Go outside and sweep up by the dumpster. Just go outside and clean up.
I'm really tired. Why can't he do it?
Well, he's doing something else right now.
You're always looking out for him.
Just do what you're told. Go outside and clean up.
Yeah, all right.
Listen, I'll see you at 7 tonight, okay?
People react to sexual conduct in different ways. Some may find it humorous. Others may find it highly offensive. The important thing to remember is sexual harassment doesn't belong in the workplace.
Sure.
Hey, would you sign this for me?
Sure, no problem. Hey, babe, can you pick that up for me?
Sure.
There you go.
Thanks.
Oh, hurt me.
All right. Hey, Jeff, did you see the new girl in the office?
You mean the one with the big hooters?
Yeah, that's the one.
I'd like to get close to those beauties.
Yeah.
Inappropriate sexual behavior isn't always about what is said. It is often how it is said. The next scene is a good example of this.
Hi, Sally. Nice sweater. Thank you.
Hi, Sally. Nice sweater. You look nice today.
Thank you.
Whoa, wait a minute. Good morning, Sally. Wow, nice sweater.
Certain materials, such as suggestive calendars, magazines, and pictures, don't belong at work.
Wow, check those out. You think those are real?
I think you should get back to work.
Man. Good looking. Oh, nice suit. How do you like that? I think you look real good in that.
Would you please give me a break?
Okay.
Sexual harassment is about power over another person, and it's against the law.
Hey, don't block me in.
Oh, come on, babe. Hey, what do you say you and I go out for a date tonight?
Let me out.
Come on, relax. Look, there's no problem. I'm just talking.
I said move your high-low and let me out.
Not until we make a date.
Not in your lifetime.
You've just seen a number of examples of conduct that's inappropriate in the workplace. Do yourself a favor. Don't put yourself in the position of being accused of this kind of conduct.
If we are called upon to defend you or your company against a claim of sexual harassment, we want to be able to show the judge and the jury several things.
We want to show them that the employer has adopted and published an effective policy against harassment. The policy should tell employees what sexual harassment is and that it will not be tolerated. The policy should also tell employees how to make a complaint and what the employer will do about it.
In addition to the policy, we also want to be able to show the judge and the jury that you notified your employees about the policy and that you put into place proper training. You should also republish your policy every year.
It is important to demonstrate that you, as the employer, followed your procedures. Once a complaint was made, it was investigated and appropriate remedial actions were taken.
We recommend that employers have a procedure that encourages employees to bring their complaints forward. If a supervisor is harassing an employee, the employee should have a way to bring the complaint without taking it directly to that supervisor.
Thanks for taking the time to stop by the Human Resources Department to meet with me. I hear that you have a complaint, and could you take a few minutes to share with me what has happened?
During the investigation, the employee should be encouraged to specify the details of the complaint. This involves asking the basic questions: who, what, where, when, why, and how. The investigator should also ask for the names of other people who may have witnessed the offending conduct. The investigator should encourage the individual to put the complaint in writing.
The investigator should also talk to the person accused of the conduct. The person should be asked the same basic questions: who, what, when, where, why, and how. The accused should also be asked the names of persons who may be able to affirm or deny the offending conduct, and the accused should be asked to put his or her response in writing.
I've received a complaint about you and your conduct. I need to really understand what happened from your perspective. Could you help me out?
Upon completion of the investigation, the employer must determine what steps are necessary to correct any problem that has been found.
There are a number of steps an employer can take. These include written warning, demotion, transfer of the offending party, suspension, or even termination of employment. It's important, though, that the investigator fully document the steps taken during the investigation.
Most claims of sexual harassment don't need to end up in the courtroom. In most cases, the employer can resolve these complaints internally by adopting an effective policy, encouraging employees to come forward with claims of sexual harassment, and promptly investigating and resolving the complaint. Most allegations of sexual harassment will not result in a lawsuit. But if they do, by taking these steps, the employer will be in the best position to win.
The potential liability in sexual harassment lawsuits is enormous. In addition to the financial risk, these claims can be devastating to an employer. The emotional costs are high, and careers can be ruined. Every employer, every manager, every employee should take the issue of sexual harassment very seriously.